least. Glad to see all of you here this morning. My name is Ian Simpson from RuleMatch. It's my pleasure to welcome you to the first day of the Crypto Valley Conference here in the lovely city of Rotkreuz at HSLU, at this lovely location. For those of you who don't know, this is the 6th year of the Crypto Valley Conference, quite a record when it comes to longevity and sustainability, perhaps of a different sort. I also have had the pleasure of being involved in the crypto and blockchain scene in Switzerland over that time. Much has changed, actually, since 2017, as maybe some of you know. But one thing that has not changed is that legal and regulation is still very important. And as we like to say at RuleMatch, playing by the rules still pays off very much. That, of course, is going to be the topic of some of the first sessions today here in this room. The first panel, I have to warn you, is very in-depth, very involved, very detailed, and there are quite a few people who will bring in their knowledge on the subject today. You see their names here, but fortunately, to guide everybody through the topic, we have an expert moderator. So I'd like to welcome Katharina Lasota Heller from LEXCELLENCE and her guests for the first panel.
So, good morning, everybody. We have a proper order. So, if you forget the names of my guests, you can always have a look up. It's early, I get it, but for more than 6 years already, regulatory and legal, especially regulatory issues, are more than important for the crypto industry. Some like to say that it's one of the, let's say, almost deal breakers in some of the business models. Let's don't be so pessimistic, and let's to have some holistic approach to this. So my name is Katharina Lasota Heller. I'm a lawyer, I'm an attorney at law with LEXCELLENCE, law firm here in Zug, but most importantly, I'm co-chair of the regulatory working group with Crypto Valley Association, together with Reto Lutiger, who unfortunately cannot be with us today, but this is what we do. I don't have to tell you much about Crypto Valley Association itself, I guess, because we have so many guests here, and I know as the day will develop, there will be more people, but I want to tell you a few words about the regulatory working group, what we're doing. We are a group of quiet skills experts, really doing it pro bono. We meet every month and discuss issues related to regulatory development. There is another group dealing with AML, but we're somehow working together anyway. And we share knowledge. We invite very interesting people, but most importantly, we provide feedback to regulators. Our two last initiatives was paper on staking, where we somehow explained to FINMA that not every kind of staking needs a banking license. It was quite a success. FINMA understood, so we good. And the last one, we issued a statement to European Commission on reverse solicitation issues under MiCA. We will have a lot of discussions today, many discussions concerning MiCA. On this panel and on the 3 subsequent panels, if I saw in the agenda correctly. So stay with us, important issues, and this is what we're sharing today. It's a unique opportunity for you because, as I like to say, it's usually quite expensive, so you can have the insight today just when we hear at the conference. So with me is Dominik, Dimitrios, Joshua, and Crystal. How it will look. They will have 1 minute to introduce themselves, then we will go into 2 rounds of questions, and at the end we will have some key takeaways. So, Dominik.
Perfect. Thank you very much, Katharina. I'm Dominik. I'm also a lawyer. I'm working at support at MME, and I'm in the crypto space since 2016. And the question that I'm currently most focusing on is the connection between financial market regulation and technologies. because most of the projects I'm dealing with, they need these both aspects to be understood in detail from both directions. So on the one side, regulated businesses like bank integrations, asset management, exchanges, stablecoin issuances, which all depend on understanding the technology properly to explain to the regulator how the existing regulation can be applied with using this technology. And on the other side, a lot of DAO, DeFi projects, which similar considerations are relevant, but from the other side around. So to actually explain why this is, due to decentralization, a totally different setup, different risks, different understanding, which allow also a different regulatory approach.
Thank you very much. You were in time, Dimitrios.
Thank you very much for having me, Katharina, here. I'm very happy to be here with you. My name is Dimitrios Psarrakis. I'm financial economist by training, and I was for 7 years economic and monetary policy specialist at the European Parliament, drafting the blockchain resolution of the Parliament that created the framework that now gives headaches and pains to Katharina and the other fellow lawyers here. Co-draftsperson of the Title II and Title III of MiCA and the DLT pilot regime was my last regulation before leaving the Parliament. I'm board member of GBBC and co-founder of ValueVerse, a company specializing on building financial economic business cases on tokenized assets. And my main pain point at this stage is to explain to the European Commission why we need a deep economic understanding of why to tokenize financial instruments and real-world assets, and what kind of further regulatory initiatives we need to do in Brussels in order to facilitate this innovation.
Thank you very much. Joshua?
Thank you. Welcome also from my side. I'm Joshua Taucher, legal counsel at Sygnum Bank. And working in such a role, I think we always see these topics of regulation, but also of technology, development of both these topics, and working in a way that you can always ensure compliance, but also be innovative on not just on the technological side, but also on the legal and regulatory side. So topics like staking and also MiCA, I think, are topics that keep us busy, but that are also really interesting as a lawyer to get to know and find solutions that work for us.
Thank you. Hello. Hello. So my name is Crystal. Thank you for the intro, Katharina. So I'm an attorney at law at Bonnard Lawson International Law Firm. We are a law firm based in the Vaud state in Switzerland, but we have offices as well in Dubai, Paris, and in Hong Kong and Shanghai. So I work in the technology and fintech team, and in this team we work with many different kinds of crypto projects. We help them from the beginning of the project to set up the legal framework, and then we continue working with them when they reach a certain stage. So it's, as my colleagues mentioned, it's all the legal issues linked with technology and regulatory financial regulations.
Thank you. So today we will be talking about not only regulatory, not only AML, we will be talking about current issues which affect crypto industry, including AI and cybersecurity. So that's the new topics which we also will be touching on today. Important thing, if I didn't mention this, we all, with the exception of Dimitrios, which we hope he will, we all members of the regulatory working group. So we all actually actively work on those issues every 4 weeks. So we're happy to be here. And now let's start. As you know, crypto industry is one of the most global ones. And if there is a country like Switzerland, when we started 2016, the whole odyssey through crypto world, everybody was coming here saying, oh, ICO Switzerland and so far on, it's possible. Yes, it is possible, but what is even more important is not the country where you're issuing, but where you're offering. That's really what you have to keep in mind. And having this in mind, I want to come to Dominik and ask you to provide us a little bit feedback and to explain to people what are the last 2 SEC decisions on ETF spot trading, that they will understand what is this about, basically. Mm-hmm. So,
Thank you. So the SEC's decision on allowing BTC ETFs and also principally allowing Ether ETFs were quite regulatory milestones. I guess most of you perhaps have read it in the newspapers, so it was widely covered. It was a particularly a milestone because the SEC is known as a very crypto-averse and critical regulator, and it has been pushed by judicial decisions in the US, political motions, to actually, I wouldn't say embrace, but accept that there are these financial instruments that can be listed, sold, and traded in the US, like BTC, ETFs, and now in the future also ETF. So on Ethereum, however, the latter ones have not yet been approved as an individual instrument, but as a basic principle allowance that this should be possible. However, it needs also to be kept in mind that these are indirect exposures for the investors, so you don't own Bitcoin or Ether if you purchase these instruments. You have an exposure indirectly, and that means you cannot directly interact with these financial innovations of DeFi or other Web3 applications. In Switzerland, the approach is a bit different. It is generally more crypto-friendly, and it allows you to hold more directly your crypto also with regulated providers like banks, we also Sygnum here today, and others to have a direct exposure to crypto. And also, and perhaps also therefore, the ETF road is not so much followed in Switzerland. There are also different, apart from that crypto is the underlying regulatory reasons why there are no such ETFs, but there are ETPs, which are there since many years, listed on the Swiss Stock Exchange, and give you quite a similar exposure here in Switzerland than an ETF. Main difference, they are not bankruptcy remote, but there is a lot of collateral requirements specifically designed to mitigate these risks and give you a very similar economic structure than these ETFs.
Well, have you ever thought about it where there is such business model, like basically the fund is directly trading with Ethers and Bitcoins, like in those SEC decisions? Will this require a license in Switzerland? Or
So yes, of course, if you do like a fund structure, which is a collective investment scheme, you pool money to actually invest into something, and it also can be Bitcoin or Ether, you need to have those respective licenses. However, always it needs to be looked at. Is it a foreign structure that is sold into Switzerland? Is it a Swiss structure that is only offered to Swiss market? As you said, the cross-border issues are important, and also these US ETFs. It's also the question how and to which extent you can purchase them in Switzerland. However, currently I think with the ETPs on the stock exchange, we have quite a good market already there.
yes, so it's getting better. I specifically asked the question because many people are coming and asking, hey, do I need a license for this or other business models? So I think it's quite clear, yes, you need always, as usual, the issue is in details, but generally, yes. So, Joshua, let's stay a little bit in Switzerland and the staking issue, which we had here and are still having. So, you are in legal counsel in a bank. Imagine 6 years ago we would have not have here anybody from a bank. So you see the development actually. So how you deal with the staking activities? What is your take on this? What's the approach in Switzerland? And give us some feedback.
Yeah, I think the staking discussions got quite hot last summer when we received first indications from FINMA that they want to require entities offering staking services to have a banking license. Why was that? Because the LT Act introduced 2 new provisions stating that, or to ensure that crypto assets held with a custodian can be segregated in the case of bankruptcy. And one of the requirements to ensure that was that the assets held at the custodian are held available for the client at all times. And so last summer we received kind of the indication from FINMA that this is not the case with staked assets because there's the risk of slashing, but there's also the unstaking period. And this then started quite a discussion in the industry. I think it was a good example to also see that the industry needs to come together and also educate each other, but also start conversations with regulators. This then led to FINMA publishing the staking guidelines in December last year, and that I think was a big step towards more clarity on that topic. So we received guidelines on how can you do it, and we also received clarity that you do not require a banking license to stake. And if you have a banking license, you do not need to take staked assets on your balance sheet. So I think that was a big step on giving us clarity in the market. Of course, there's still open questions on how you do it and how to implement it, tax-wise also. But there's still a couple of open questions also on the private law side. But I think we can be quite happy with FINMA's circular.
At the end, yes. You may wonder, some of you, why somebody from a bank was actually not very satisfied with the statement of FINMA that a banking license is needed, because a bank has a banking license. So if you just could give a short feedback on how much assets you would have to have if it was running, if it was run under banking activity.
Yeah, I think maybe first taking a step back, I think it's also, with this industry, you shouldn't see yourself as just we as a bank, and it might be an advantage for us if only bank can provide this service, because I think we're in this together and we benefit from each other if we can establish an environment for the whole industry. And coming back to that question, so if only banks could do staking, but under the first indications of FINMA, a bank would have to take staked assets on the balance sheet, and this would then require capital requirements, which were quite harsh. So staking business would even as a bank not be really interesting to perform anymore.
Okay. So if you want to see our statements and the statements on FINMA, the one on FINMA is on the homepage of FINMA. Our as Crypto Valley Association is on the website of Crypto Valley Association. Read it. It will be good guidelines for you how to structure the business. Perhaps your business will not require a banking license. Now, I will come now to Dimitrios, because we stay in the sphere of crypto assets. Dimitrios. We have MiCA in Europe, in European Union, Marketing Crypto Asset Regulation, and it was supposed to be all clear and fantastic and easy, and I guess this is still not the case. Would you give us some feedback? What are the still open questions under MiCA? Not only from us, for the third countries in relation to reverse solicitation, but also in Europe. ESMA had some consultation running, so anything still open?
2 minutes.
2 minutes.
Wonderful. Okay. First of all, we are very happy having MiCA, because MiCA is an excellent regulation to put legal certainty and regulatory clarity in a very difficult and very fastly evolving space. Obviously, we have not all the answers in MiCA. MiCA was a regulation for centralized entities, and much of what had to be there is not there. For example, staking is a crypto asset service that is not included, and if we had the opportunity to open the file again and add something over there, staking would be in. There is a high probability staking would be in a MiCA 2, possibly in the first quarter of 2026. This is going to have another dimension also about what we're doing with NFTs, that mainly because of me, it was excluded. It seems that it had to be in for reasons related to single market, instead of being prey to 27 different consumer protection regulations. It's better to have them in one place. And the obvious challenge in MiCA, because we don't practically have MiCA yet implemented.
On 30th of December.
On the 30th of December, we have the stable coins part. And we are going to have, from what I'm hearing, only one major stablecoin authorized, Circle. Other than that, no stablecoins whatsoever will be in MiCA on the 30th of June, but we don't care, because we don't have cusps to delist them before the December 30th. So this is something we need to take into consideration. The obvious question is how this MiCA world will actually be implemented in practice. And people focus on MiCA. It's not MiCA. If you are a crypto asset service provider, you have to abide, depending on what kind of services you offer, with 24 regulations. If you are an e-money token issuer, you need to abide with 11 regulations. So the constellation of regulations working together is a big, big question mark because it generates systemic effects and questions.
Yes, I still need to ask you one question, and I keep asking this every time, and I hope I will get an answer. Why on earth you changed the definition of asset reference token between the wording 2020 and the 2023?
What you mean? You mean the recital of the European
Yeah,
Parliament?
what's the asset reference token was supposed to be a token which is reference to another crypto asset or fiat money. And now what we have is crypto asset, fiat money, or another right. And this is where we're starting having problems, especially in relation to reverse solicitation. Is it financial instrument or not? Is it covered by MiCA or under MiFID? And if this is MiCA, the reverse solicitation issue is much more stricter.
Okay.
So why you changed the? Why was the change of the?
Your question is not about the definition of asset reference tokens, but about reverse solicitation.
No, but first one is about the definition of the art.
I suspect that I like the new definition of the asset reference tokens simply because it gives more room to have a basket of whatever asset you want to have and tokenize whatever you like, as long as you have an a MiCA license to do so. Mm-hmm. Who is entitled to go to the national competent authority of the member state and issue an asset reference token? Somebody who wants to issue a token of this space. Where to issue? And this is the reverse solicitation question. Obviously, reverse solicitation is a major problem that we had in Europe in the last 65 years. It's not new. And we don't have a threshold clear as in the United States that says you cannot offer the service to an American citizen. Clear, full stop. We don't have a threshold though. We cannot say more than 25 people, than 25,000 people. You cannot do that. So, what is the message of the regulator? If your main group of clients resides in Germany, then you have to incorporate your entity in Germany, end of story.
That's clear, and we know it's much more stricter. My question
reverse
was
solicitation cannot be a business model for a company.
That's clear, I know. Now my question was because due to the change of the definition, we started having problems in defining what is financial instrument under MiFID and what is not financial instrument and under MiCA.
You have the problem in Title II. Because if you are another token, and your token is qualified as a security in Slovenia but not in Poland, and you have the passport from Slovenia, then you have the problem of explanation what the hell a security is. So it's not asset reference token, it's everything. The question is about a MiFID 3 with a definition of what is a security or not.
Yeah, but anyway, we see there is still a lot of work to be done, and now because we started talking about assets, so and somebody needs to hold the assets, and not every of us is IT engineers who cannot mine their assets, so we need to have somebody who is storing them securely. So now I will go to Crystal, and we know all DORA is coming in European Union. If you don't know, Digital Operational Resilience Act, something that is really directing financial intermediaries. We have AI Act coming up, defining then financial services are high-risk activities. So what is the take of Switzerland comparing to European Union?
So we can say that Switzerland has been less prolific in terms of regulations than the EU. If we just come back to the AI Act, so it can apply to Swiss developers and deployers of AI systems and general purpose AI models, so Swiss-based entities, individuals and bodies that could also apply to decentralized technology protocols. For instance, it's not clear, but we will see how it is implemented, but this is something to think about. We'll have to apply, will be in the scope of the EU AI Act. The EU AI Act, broadly in 1 minute, so it classifies AI systems into different risks level, and depending on the risk level, the developers or deployers have a different set of obligations. There is the unacceptable risk that is prohibited, the high-risk AI systems that need to fulfill a list of obligations. So I will not go into details today because the list is long. And there is also the limited AI systems risks. And these are just subject to transparency obligations. So this is, for instance, chatbot and deep fakes systems. So the final text has been not yet published, but it will be published in the upcoming days. So then once it's published, the regulation will be applicable six months from now and until 36 months. So it's a very hot topic, I would say. And we will see how it applies to decentralized technology protocols. In terms of DORA now, so DORA is a cybersecurity act. It is aimed at financial institutions, and it is aimed to regulate the cybersecurity and ICT systems within financial institutions. So it's more like a compliance act where ICT systems needs to fulfill a certain list of criteria. There needs to be risk assessments put in place. The third-party ICT providers need to fulfill also some obligations. And this could be applicable in Switzerland for ICT providers. And ICT providers also entail blockchain technology providers. So that's why it's applicable in Switzerland too.
So thank you. Why we're talking about this, because, and I know Dimitrios will have a word to it later, it's just what you see, what is happening in European Union now. They're saying, you know, the guys, whatever, if you're offering crypto assets, if you're offering financial services, if you're offering ICT services, providing services for financial intermediaries or service providers, you have to have representation in European Union, full stop. And European Union just decided they don't care. We have how many millions of citizens? It's your great story.
450 comparatively rich.
If you want to come there, if you want to offer, you need to adhere to the principles. This is why we're discussing them today, because it will be important not only for Swiss companies, but from any other third country company, let's say Singapore, Hong Kong. I know there's delegation from Hong Kong today. It all will be important for those companies as well if they want to enter European market. So now they're going to a second round quickly, and we start with Dominik. DeFi and DAOs, what's to expect?
I just see the time, so I keep myself short.
I think we have another 6 minutes because it started later, yeah.
Briefly, there are a lot of interesting projects on our table and a lot of it's going on. So there's innovation, there is development in the DeFi DAO space. And I want to briefly focus on, let's say, the underlying principle of something being DeFi or DAO. It's the D, it's the decentralization. And we see currently globally more tightening regulatory initiative to really define this and to question whether most of the projects, they actually are sufficiently decentralized to be outside of financial market regulations. And the good thing here in Switzerland is FINMA as a regulator clearly accepts that there is full decentralization that exists, and it also has set some indicators which they have publicly referenced to what they would see as an indication for not being fully decentralized. So control over smart contracts, clear indirect control via DAO governance, dependency on exclusivity of access, etc. So there are a lot of things which finally boil down to trust into a single operator. So if there is a project which has a project team that needs to run things into which the community needs to trust to actually use the application, then it is likely not seen as fully decentralized. Whereas decentralization from a regulatory perspective goes hand in hand with the philosophical concept of trustlessness in Web3 and blockchain. So if there is really no one you need to trust, it's independent from everyone, it's pre-programmed, it's autonomous, then it also does not fall under Swiss financial market regulations. Now, this principle, of course, is sometimes in the day-to-day work difficult to uphold clearly, and therefore the question always is for a project, do they on the long run intend to really build something that should be community run, or do they actually want to do something that's more centralized, but they just want to use a DeFi as a mantle? And it's clearly recommendable to use your energy, your efforts to innovation, to build this decentralized aspect and to live up to the promise of DLT and blockchain, and on the same time also then build something new that has a totally different risk structure and allows a regulator also to exempt it from regulation, not by just being decentralized by name, but being from a conceptual perspective something different and something new. And there are a lot of use cases that can be seen there in the future. It can also give more security to banks, limit credit crush risks, etc. So there's a lot of chances and opportunities there if this principle is fully followed.
Let's see. I cannot say who, but it's a very famous scholar. I said at a conference 2 years ago, the conference was under Sygnum rule, saying I cannot say who, but I can say what was said. He said the only real DeFi was Uniswap version 1. Whatever after came, it's probably not really DeFi, but we can discuss, and I know there will be discussions, but I just want to, So, Joshua, how should Swiss and maybe third country CASPs and the crypto asset service providers, also like a bank, apply the reverse solicitation rule under MiCA?
I think we probably heard the answer before. There's,
It was clear, I solved the problem.
Just in general, let's discuss, right?
You shouldn't put the business on pure reverse solicitation and try just to do that. I think that will not work. We saw ESMA publishing draft guidelines on reverse solicitation under MiCA in the beginning of the year, and I think they were quite clear what the intention is. So the intention is to be I think you can say even more restrictive than under MiFID II, and so going forward they even recommend the local competent authorities to do active searches on social media, to check whether the websites of an entity kind of implies a presence in a European country, and also to implement monitoring tools for social media. So I think we can see where it goes. So I think the recommendation would be really careful on what you do, and don't try to use reverse solicitation as a business model. Yeah.
Will this be a problem for the bank? You will be rather approaching the European market, or rather will stay away and be very, very passive, that people will come over to you?
I think you can see it both ways, that there's some restrictions, but there's also some solutions to it, and to find ways, compliant ways to address European markets, to establish maybe a presence in the European Union or EWR. So I think there's ways to deal with it. Yeah, I think it goes both ways.
Let's see, I think no final word was said, because ESMA is still working on the consultations, so let's see what will be the interpretation at the end, what really reverse solicitation is. So now, Dimitrios, we have less and less time, but any plans to digitalize assets in European Union? There is something coming up, to my knowledge.
Well, first we have the DLT pilot regime, my favorite regulation. It didn't go very well because exactly the amendments I filed were not carried through. However, this is the real elephant in the room, because all these crypto assets you see under MiCA are just dwarfed in front of the tokenized assets you can have in the real world in the financial sector. I believe that the next round coming after the European elections is going to address the fundamental issue of how the existing regulatory framework can apply to a massive tokenized financial instruments in DLT-based financial infrastructures, from placement all the way to trading, clearing, and settlement. And this also has the final leg of the funds. We don't need CBDCs to settle a transaction in a fund
We will come to it.
EMTs are funds per Payment Service Directive 2 and also amends the e-money directive in MiCA. So you don't need CBDCs in the European Union to perform this action online. Now, is the regulatory framework appropriate? I think no. We need to change the Market Abuse Directive, the Listing Directive, MiFID III itself, and fundamentally to understand what is the economic problem we solve. Because in the end of the day, it's not the regulation the problem, it's why the hell we want to tokenize an asset. What kind of problem we solve, and what is the expectation. And as we are moving from proof of concept to proof of value, this is a fundamental issue to answer.
So there is still something coming up.
A lot is coming.
A lot is coming up. And new election, let's see what will be the MEPs. They will know about it. But Crystal, now coming to you. So we're talking about those crypto asset service providers and people who may mine and but we still have also trustee services in blockchain. So anything about this here?
So yes, so when we think about a blockchain project, generally, so they could be DAOs, but DAOs are also have often an association that is associated with the DAOs to represent the DAO in the traditional market. You also have foundations that are overseeing the protocol project sometimes. Another way is to think of trust vehicles. So this is something we have been doing for the last few months on a few specific projects. And I want just to highlight the benefits and maybe the challenges with trust structures as a future development. So the benefit of a trust vehicle is that it ensures security and prosperity of the assets that are put in trust. So in terms of a protocol, for instance, the assets that could be put in trust could be the proprietary intellectual property if it's not fully open source. It could be private keys to a specific smart contract or to a wallet. And then why it ensures prosperity is because the trustee has strict rules to follow based on the wishes of the settler, and so you ensure that your project follows a certain guidelines on the long term based on the assets that you put in trust. The trustee is also a regulated entity, so sometimes it can bring more liability to a project, or it can bring more expertise or more trust into a project as well. And finally, it can represent the trust and act as an intermediary in the traditional market. The challenges are that trustees are not all well-versed in digital assets, so it's sometimes difficult to find a trustee that has the infrastructure in place to be responsible for the responsibilities that it has. So this is the first challenge. The second challenge is that a trust is not a structure that could be used for fundraising, for instance, so it has a limited scope of activities, I would say, so it should be used in a framework where it really is to safeguard and to ensure the prosperity of a project. And the third challenge is also the timing of when you should think about setting up a trust. Usually it's at the initial stages of a project, because then after the trustee is subject to specific regulation, AML regulation, it becomes complicated once the project is established to set up a trust on the long run. But we see developments, and I think that trustees are also working on integrating digital assets in their business lines. So I think it could be an interesting legal entity to think about in a framework.
Interesting. Now we have really 1 or 2 minutes left. It's just another topic which I would like to really touch is the CBDCs, right? So, you know, Switzerland decided to introduce CBDC, like Helvetia 3 project, just for wholesale trading. So not for consumers, not for retail. And now, guys, to you, just a question, because European Union is going to issue digital euro up to 3,000 euro per person, basically. And to you now, we know, Dimitrios, you totally against it. It just doesn't make sense to have a CBDC, what you just said.
We don't actually need a CBDC.
Okay, you don't need, we don't need CBDC. Now from you, yes or not, and then we will finish here. And if you guys want to know why yes or not, talk to us in the break. We will be there to answer your questions. Crystal.
Yes, but with the right technology in place. Like
Privacy, I guess. Joshua? From a bank perspective?
If it's a yes or no, I would go with probably it's either a yes but or a no also but. So I think it depends on how we structure it.
Okay.
Same here. If it's like cash, so
Yeah.
it has the same rules, it's not traceable, it has a privacy enhancement, etc., then yes, otherwise it's not a benefit.
Okay. Thank you very much. If you have questions, we probably don't have time for questions. Not really. Unfortunately, we're here. We have 3 fantastic panels now to come, but later you can basically ask whatever you need. Thank you very much. Yeah.